Hello and welcome to the latest installment in Beresford Booth's ongoing series of webinars. My name is Todd Cook. I am a member of the litigation and real estate groups here at Beresford Booth. And today I'd like to talk about a subject where my two groups converge, and that is at the on-site mediation of boundary disputes. So first, I want to talk about what we're going to talk about, and we're going to cover a background of what is a boundary dispute and what is a traditional mediation. And then once we have that background, we will go on to discussing the main topic of what is and why would we consider doing an on-site mediation when we have a boundary dispute litigation. So what is a boundary dispute? So a boundary dispute is a legal dispute over the location of the common boundary between two adjoining properties. This happens all the time in Washington state, and many of the boundary dispute cases grow out of the doctrine of adverse possession. Adverse possession is a legal doctrine that I'm not going to get fully into, but through the process or a doctrine of adverse possession, one property owner can have a claim to ownership of some or all of another property owner's land. And what that results in is a dispute over where the boundary line between those two adjoining parcels should be. Now, this is a particularly emotionally charged type of dispute because, in my experience, property owners are very hold their property to be very sacred, and so it is very difficult for a property owner to agree to give up some of their land when there is a property boundary line dispute raised, and it makes it difficult for them to judge and weigh the costs and benefits of the dispute. And so when a boundary line dispute arises, if there is agreement, the parties can go through a administrative process of adjusting the boundary line through the municipality, either the city or the county. But when there's disagreement, what often happens is a lawsuit is filed and the dispute enters the judicial system. And that is typically through a claim filed by one of the parties to quiet title to the disputed land, and the goal in that lawsuit is to get a written judgment from the court that declares who owns the land, and if it is only fighting over a portion of land, that basically redraws the boundary line between the two adjoining properties. So once you're in litigation, you're either going through the whole litigation process and you're going to get a litigated judgment that the court issues at the end of the dispute, or you're going to try to settle and you're going to end up having a negotiated judgment that resolves the boundary dispute. So once you're in litigation, in all cases, it is a good idea to see if the parties can resolve the case. Because once you're in litigation, if you go to trial, there's a lack of certainty. You're putting the outcome of your dispute in the hands of a judge or a jury, and you lose control of the outcome when you're having a third party, such as a judge or a jury, decide. So settlement is a good way to have some control over the outcome. And mediation is just a special device, a special kind of settlement discussion. So the parties can negotiate directly attorney to attorney, or they can engage in a mediation. And mediation is a structured settlement discussion led by a third party neutral who goes back and forth between the parties, tries to educate the parties about the risks that they're facing and the potential outcomes that may result. It's a discrete event. It's typically not an ongoing thing. It's one day you go to the mediator's office or an attorney's office, and there's shuttle diplomacy between conference rooms, one for the plaintiff and one for the defendant. And it's a voluntary process, so there's no outcome guaranteed. The mediation may fail, and you simply go back to trying the case through the litigation process. So the pros of a mediation is they're relatively inexpensive. You have to educate the mediator through mediation statements that you have to prepare, and you have to pay for the mediator's time that is generally split between the parties for 1 day of the mediator's time typically. So it's relatively low cost because if the settlement is successful, that cost typically pales in comparison to what the cost of a full litigation would entail. It's good because in a case, the parties get very entrenched in their own positions, and they're typically only hearing from their attorney who is advocating for them. So it's good to hear from a third party who can serve as sort of a proxy for what the judge or the jury in the case how they may react to the claims, if the case gets to trial. And as I said, settlement gives you some control over the outcome, and if it's unsuccessful, you just continue mediating. But there's not many cons. I mean, one of the cons is that nothing is guaranteed. The mediator is not a substitute for the judge. So the mediator, if there's disagreement that can't be bridged by the mediator doesn't step in and impose an outcome. The case just continues settling and continues litigating, and the mediation fails. And it will fail if the parties are too entrenched or just not ready to settle. So what is a traditional mediation look like? Well, a traditional mediation takes place in the mediator's or the attorney's office, typically in a series of conference rooms. One party and their counsel will be in one conference room, and the other party and their counsel will be in a second conference room, and the mediator will go back and forth between the two conference rooms, trying to educate each side about the risks that they face, trying to help them see the other side and what outcomes may result if they go to trial. The cost of trial is one of the issues they discuss, but it's in a conference room typically. And so the mediator has access to the parties, they have access to the mediation statements that were submitted, and then they have access to the things that the parties bring with them, such as photos or videos. But the settlement proposals are exchanged in a conference room environment. So you don't have the benefit of seeing in real life the land that you're dealing with if it's a boundary dispute and you're in a conference room. So that brings us to why mediate on site. Now, I have mediated many boundary line disputes through the typical traditional conference room process. Some have failed, many have been successful, but I've recently participated in my first on-site mediation. It was proposed by the other side, and I actually thought that it was a really effective process, and that's why I want to share sort of some of my thoughts on it. So, as I said, in the traditional process, you're in a conference room, boundary lines are negotiated with words or lines on maps. But if you're on site and a boundary dispute is between two adjoining landowners, so it could be residential and each party could have a house where they reside on the respective two parcels, or it could be between businesses and they have office space. But it's a unique case. A boundary dispute is a unique case because there is a location that is factually relevant to the case, and it's a location where there's typically a structure where that can substitute for the conference rooms. So in a residential to residential, essentially the plaintiff stays at the plaintiff's property, in their living room or around their kitchen table, and the defendant stays at the defendant's property in their living room or around their kitchen table, and the mediator goes back and forth between the two houses and has the benefit of going out into the yard with the property owners one at a time to talk about and view the actual land that's in dispute. And instead of making proposals that are based on lines on map or just words conveyed, you can use markers. You can put stakes in the ground to represent your proposal of where the boundary line should be adjusted. You can use a combination of stakes in the ground connected by strings that will visually show this is exactly what we're proposing. And then the other side can make their counter proposal through a second set of stakes or strings on the ground. And so it's a very visual process, and the parties can see exactly what they are negotiating and what the impact of a settlement on those terms would look like in very real terms. And they can adjust for landscaping features or contours that may not come into play when you're in a office environment and just exchanging written proposals through drawings with lines on a survey map or things like that. And if you do come to an agreement through a set of stakes that ultimately everyone agrees to, you have it marked in real, in the real world on the ground, and then you can the parties can bring out a surveyor to legally describe the exact line on the ground that the parties have agreed to. So I want to give some examples of what this would look like, just so you can see really the difference. So the first example is an example of a conference room proposal, what it might look like. So here we have essentially, this is just rudimentary, something I drew for this example, but you have a survey map and it has two lots, or maybe it's the plat map that shows the two properties, lot 1 and lot 2, and they're adjoining. And party 1 makes a proposal to move the common boundary line 3 feet to the east of the record boundary as depicted in a red line. So the plaintiff, or maybe here the defendant, gives this proposal and says, this is what I'm willing to do, give up 3 feet of space to you. And the other side, when they get it, this is what they see. And they may have pictures that they can look at, but they're evaluating this proposal with this visual depiction in front of them. And if the other side doesn't like it, they may come back with a counter proposal that no, we need to move the boundary line 5 feet to the east as depicted by the blue line. And so, what's at dispute here. There's a 2-foot difference between these two proposals. But sitting here, you don't really know what that 2 feet, what that is going to look like, what that's going to feel like in real life. And so, many boundary line disputes have been resolved this way, but it is a process that just doesn't give you as much information as if you are on site. So now I want to give an example of what an on-site proposal might look like. And obviously, I'm not going to take you on site anywhere. So I've just taken some pictures. This is our lovely office building in Edmonds, Washington, serving as a fictitious land. And so on the left here with proposal 1, one party may put stakes in the ground at point 1 and at point 2. They may try to connect them with a string and say, this is our proposal. We want to move the boundary line to this specific line. And they may have a rationale for doing that, but the other side may see it and say, well, this line cuts through all of these trees, all of these young trees. And that could cause problems because those are going to become boundary line trees that we're going to have common ownership over, and that could cause problems in the future. And they might not realize that if they're just in the conference room drawing lines on a map. So here, I've made a fictitious counter proposal where instead of connecting line 1 and 2, we're now connecting line 1B to point 2. So it's the same endpoint on the far end, but in the close end, it's moved. The line is moved to the left a few feet. And the reason here is this is putting the line between these two rows of trees. So this is a proposal that would account for the fact that there are landscaping features there that could cause a problem in the future. And so it is a very good process if you're on site here, because the parties can see this in real time. So if you're engaged in this settlement negotiation, you're literally walking in your yard with the mediator, and there's this red line staked and represented with a string on the ground, and then your line with the blue line also staked. The two sides can see, okay, this is what we're fighting over. We are fighting over this small, we're almost together, to a settlement, but we're fighting over this, small triangle in between the lines. And when you're in a conference room environment, I think it tends to lend itself more to emotional outcomes of, well, I don't want to give up that much space. I like 3 feet more than 5 feet, or they shouldn't get that much. But you don't really have a rationale necessarily for, what is the difference between that 3 and 5 foot, difference. But here, if you're on site, you can see it. You can, put yourself in the perspective of what would this be like if we agree to this. What would the outcome be? Is this land, this triangle of space, worth the continued fight and cost of litigation? And obviously, these pictures don't put you in that same feeling, but it is a really good, I found it to be a very good process for really driving home what a proposal is in very concrete terms, and what the risk reward could be of agreeing to it. Is this area something you can live with? Is this disputed area between the lines that we've staked on the ground, is it worth continuing to fight about, or is this something we can live with? So I've found it to be a very good process. It brings clarity that you can't get in the same way with just a written proposal with lines drawn on a plat map or a survey. It gives the parties an opportunity to experience the proposal in real life, walking the area, being in their own yard, and being able to put themselves into the position of what would this feel like on a day-to-day basis if this is the new line. It really helps in the cost-benefit analysis, allowing them to see that in real life. And it gives them the opportunity to tailor the solution to the conditions on the ground. So it's largely the same process. It's exactly the same process as a traditional mediation in an office building. It just has this great benefit of having the disputed area there in person for everyone to experience, and it gives just great clarity to what the proposal is. So I was very happy with the process. Hopefully you've learned something through this discussion, and if you are in a boundary dispute, you'll consider a mediation on site. If you have any questions about a boundary dispute or the mediation process, feel free to reach out. My name again is Todd Cook. and my contact information is on the screen. I thank you for spending the time with me, and have a great day. Thank you.